Thank you, sir. Dear fellow surveyors, colleagues, peers in the industry, this year the topic I have chosen is one dear to me, having been involved in several instances, and I'm sure it's of interest to a lot of people in this fraternity. I like to think of risk assessment, risk management and compensation as the 3 Ps, and I'll explain why. I want to touch upon a few aspects of the assessment and management, but essentially this paper is about compensation. I'd like to run through historically how the compensation regime has been developed and where we are at today. Now, what is the risk in pollution? So we understand there is damage to environment, there's property, there's loss of livelihood, there's disruption of the supply chain, and there is negative public scrutiny. So in this day and age, let me explain these last 2 aspects because the above 3 are very apparent. For any oil major to have suffered a casualty on one of their ships is just not a loss of cargo, but the scrutiny and the negative publicity that is faced from the public today is so immense that it takes many, many years to recover that brand image. So this is something that needs to be addressed, and way back in 67, in the Torrey Canyon case, which was the trigger, we had this 1969 CLC. This is the historical aspect of how we developed our present regime. And the convention, of course, was limited at that time to 14 million SDR, which was found to be sufficient after that incident. But as we saw later on, it was not. And in 1971, we had the Fund Convention, where the compensation was in fact increased to 30 million SDR, that is special drawing rights. And that continued for several years till we had these 3 series of incidents that I've put on the screen. The most famous of all was the Exxon Valdez. And people soon realized that even the Fund Convention with a benchmark figure of 30 million special drawing rights was not enough. And that's where we come to the present system today. In 1992, the CLC in fact had certain salient features which differed from the earlier convention, and I've listed out which are of importance to us as surveyors for us to be able to differentiate and to be able to appreciate the differences so that we are able to advise and act accordingly. Number 1, it covered territorial sea and the SEZ of member states. It included spill, escape or discharge, and for the first time it defined persistent oils. So persistent oil was defined, and one could then say that this was covered under the convention or not. And significantly, the convention also said it was regardless of the ownership of the vessel or the oil. So it was not important who owned the vessel or the oil. Now, under this convention, earlier the problem was that the claim used to be against the ship owner, and that was a difficulty. So what they decided was, okay, they can claim directly against the ship owner, but not against the crew, pilot or the charter manager. And of course, now they could also claim against the insurer directly. Even if the ship owner, for example, was defaulting or unable to meet the expenses, they could claim directly against the insurer, the P&I insurer. The only exception was, it was damage due to personal act or omission committed with the intent to cause damage. That was one exception, and the other one was recklessly and with the knowledge that such damage would probably result. Now, in all liability insurances, the principle is that the insurance company becomes liable only if the insured is liable. That means the term they use is pay to be paid. So they expect the ship owner to first pay and then be paid or reimbursed. But we know that in practice it doesn't work that way, because the insurance company comes forward and assists, because the cash flow is just not enough for the owner in a large claim to be able to manage. The CLC took that and implemented that in its law and said, okay, the third party can now claim directly against the insurer. So that became a huge advantage for the claimant. The CLC, of course, has certain exemptions, and I'm listing out the two most important ones. Warships were, of course, exempted, and so are vessels owned by the government carrying out sovereign functions. The word uses sovereign function. That has been, now there are several case laws where they have explained what is a sovereign function. So, for example, you could have a dredger owned by the government, but dredging is not considered a sovereign function, so the dredger would become liable even though it's owned by the government. So that as laws have developed, case law has now laid out what are sovereign functions which are exempted. So just because the government of India or a state owns the vessel, it doesn't automatically get exempted. And this, of course, flow from the old English law which says the king can do no wrong, and that has been now watered down for reasonable behavior. Now, the compensation itself was based on these 5 aspects. A, it was the size of tanker regardless of the amount spilled. I'll touch on this later on when we discuss the 1993 Fund Convention, how this has been developed further. But at this stage, the CLC just said it is the size of the tanker. So it had a table which laid out the GRT and the funds that were available. It also was based on the actual cost of property damage. It was naturally based on the consequential loss, loss of profit, and interestingly, it included the cost incurred to prevent or minimize the damage. So these were included. Now, again here, there was a certain, if you like, bargain. I'll come to the next slide and explain how the bargain took place in the development of the convention. But it's important to understand these 2 slides. The ship owner was initially liable, and this convention made the ship owner strictly liable. So in law, there's a difference between strict liability and liability by itself. So under strict liability, then the owner, 2 things happen. A, the owner is responsible even if there is no negligence, and B, the burden of proof shifts. Now, of course, one may wonder, why would ship owner want to accept such a liability, strict liability, when it earlier didn't exist? And these are the things you have to bear in mind. Damage due to act of war was an exception, wholly caused by third party with intent to cause damage. So the intent was important. Grave natural disaster and negligence in maintaining of navigation assets. These are the 4 conditions, exceptions which the ship owner could exempt himself. But other than that, the ship owner was strictly liable. Now, why it was done here, and this is what explains, in exchange for this strict liability clause, the ship owner got to limit the liability, because when the convention first started, the demand was for unlimited liability. So in exchange for limiting the liability under this table, as I said, the convention has a table of gross tonnage and liability. So the ship owner got to limit the liability, but in exchange, they had to accept strict liability in law. Now you can see from here, the convention has an upper limit maximum of 89.77 million GRT, and then realizing that this was not enough, the 1992 Fund Convention came into play, and here is where the application of those funds triggered off. A, if the damage was more than 89.77, if the ship owner invoked any of the exceptions that I talked about, the 4 exceptions that I gave you earlier, and if the ship owner and the insurer are both financially incapable. Now, I have not been able to explain this in a chart, but I like you to imagine that if, for example, you had a small vessel of 5,000 GRT, the Fund Convention cap remains at 189. So effectively, if you look at a graph, if there was a small GRT vessel, then the gap between CLC and Fund Convention will be larger, and as the CLC increase it to 89.77, then the difference between 189 and 87 would narrow. So in a larger ship, for example, if there is a spill, the gap between the fund and the CLC would narrow down, because the graph is moving up at GRT, but the cap for Fund Convention remains constant at 189. Here again, there were 2 differences that took place. A, bunker spills from unladen vessels were included, and cargo spills proven from a tanker, even if a specific tanker cannot be identified. Now this is important because the CLC required the spill from a tanker, which meant an identifiable tanker. So the fund convention will accept a claim even if the tanker cannot be specified, but it is proven that it is from a tanker. In other words, it's not a shore-based spill. Now, again, here the exceptions are: damage occurred in a state which is not a party, so the fund will not respond. A spill from a warship or from a ship due to an act of war, again will not respond. And if one can prove that the damages resulted from a ship, did not result from a ship. So it is apparent now that the compensation does not depend on the size of the tanker, and that is why we had these two graphs where the smaller vessels, the gap between the CLC and fund was large and narrowed down as the GRT increases. And it would be only applicable for states that choose to ratify. That means states that do not ratify are not covered, obviously. And how the payment took place was that each state that ratified it, it was not the state that paid, but oil companies, so they call them entities. These oil companies would then levy a certain charge and pay to the fund. So I think the cutoff was 150,000 tons to begin with, then later become 1 million tons to start off with. In other words, even if you have 900,000 tons of received cargo, you still pay for 1 million. And I think Japan is one of the largest contributors, India is second largest. And how it works is that the total tonnage of oil moving into the country into shore tanks is the figure that is taken for deciding on the contributing figure. And I recall it's 3 cents per such ton. So that's multiplied and that's the contribution. And that figure is called contributing oil. Now soon after the fund convention, of course, there were these series of incidents, 4 which triggered off what I'm just talking about, the third tier. There was the Brayer, the Sea Empress and Redica, and Prestige, as was just mentioned, the last paper, last in 2002. And this got to the stage where we had the 2000 Supplementary Fund Protocol. In this, even the 189 figure was found to be unsuitable. In fact, if you followed the heavy spirit in 2007, even the supplementary is not now been found suitable, so enough rather. So in this supplementary fund, this was the third tier, and here the figure was 750 million tons per incident, SDR per incident. Again, it is financed entirely by states which choose to ratify. The only difference in this financing is that in the supplementary fund protocol, the amount is split in such a way that 50% of that liability is reinsured by the PNI, and I believe that is then further reinsured in the market as a pooling arrangement. That means all the IG clubs and the clubs get together and do a reinsurance in the market, and the rest of course is borne by the oil industry themselves. So just to recap, this is the compensation regime as it stands. The first year is, as I said, 89.77 SDR as per the 1990 CLC. It was borne entirely by the liability insurers, the PNI club. Then the second tier was 2003. I said 189, I'm sorry, it's 2003 because in 1998 it was revised 2 times further from 189 and became 203. Even 89.7 incidentally was what it started off with, then it was revised over the period of years by the 1992 Fund Convention, and then as I said the third tier was 750 as per the 2003 Supplementary Fund Protocol. Thank you, gentlemen.